Hello everyone, welcome back. So today's discussion is based on an important article published in The Hindu on 30th of July 2026 titled FCRA Bill 2026, a threat to civil society organization. The article examines the recently introduced Foreign Contribution Regulation Amendment Bill 2026 and discusses both the government's objective and the concern raised by legal experts and civil society. Along with the article, the Ministry of Home Affairs has also notified the Foreign Contribution Regulation Amendment Rule 2026, introducing new compliance requirement for organizations receiving foreign funding. This topic is extremely important for UPSC prelims, mains, as well as interview because it touches both national security, NGO regulation, constitutional rights, and the role of civil society in a democracy. So, in this video, we will understand what is FCRA, why was it enacted, what changes have been made in 2026, why is the bill controversial, what are the constitutional issues, and finally, what should be your balanced UPSC perspective. So, let's begin. Firstly, we will understand why is FCRA in news. So, the Ministry of Home Affairs has notified the Foreign Contribution Regulation Amendment Rules 2026, while the Foreign Contribution Regulation Amendment Bill 2026 has also been listed for consideration in Parliament. According to the article, although the bill had earlier been postponed after protests from several NGOs and Christian organizations, it has now returned to Parliament legislative agenda. This indicates that the government remain committed to implementing these reforms. The government says these amendments aim to improve transparency, strengthen accountability, prevent misuse of foreign funds, and protect India's sovereignty and national security. However, many civil society organizations argue that some provision may significantly increase government control over NGO. So before understanding the controversy, let's first understand what FCRA actually is. FCRA stands for Foreign Contribution Regulation Act. It is the law that regulates how individuals and organizations in India receive and utilize foreign contribution and foreign hospitality. One important misconception should be cleared first that FCRA does not prohibit foreign donation. Foreign funding is legally allowed in India, but it is allowed under a regulatory framework. The idea is simple. Foreign money should never be used to influence India's political system, democratic institution, election, public policy, sovereignty, or internal security. Interestingly, before 1976, India did not have any dedicated law regulating foreign contribution. During the emergency period, the government under Prime Minister Indira Gandhi believed that foreign money should potentially influence India's political system and destabilize democratic institutions. Therefore, the Foreign Contribution Regulation Act 1976 was enacted. Later, this law was replaced by much stricter FCRA 2010. Subsequently, amendment in 2026, 2018, 2020, and now 2026 have progressively tightened the regulatory framework. This shows a gradual shift towards stronger oversight rather than the banning foreign contribution altogether. Under FCRA, organizations working in education, healthcare, culture, religion, environment, economic development, and social welfare can receive foreign contribution after obtaining either FCRA registration or prior permission from the central government. Registration remains valid for 5 years and must be renewed before expiry. An organization must be legally registered under the laws such as Society Registration Act, India Trust Act, or Companies Act. However, certain persons are completely prohibited from receiving foreign contribution. These include election candidates, political parties, MPs and MLAs, judges, government servants, employees of government-owned corporations, certain media professionals like editors and publishers of registered news media. The reason is obvious. Foreign money should not influence India's political or governmental decision making. Now let's discuss the biggest challenge. Activity specific registration. Earlier, organization broadly mentioned their objective. Now, every NGO must specify exact objective, exact activity, and exact state or union territory where it will operate. Different activity categories and different states may require separate registration fee. Existing organizations have been given 1 year to update these details. The government believes this will improve transparency and monitoring. The new rule clearly permit foreign fund for worship, religious education, preservation of religious heritage, community kitchens, theological studies. But one phrase is repeatedly used, excluding proselytization. This means foreign contributions cannot be used for religious conversion activities. This is significant because Article 25 guarantee the freedom to profess, practice, and propagate religion. However, in the landmark Reverend Stanislaus versus State of Madhya Pradesh 1977 judgment, the Supreme Court held that the right to propagate religion does not include a fundamental right to convert another person. Therefore, the amendments align with existing constitutional interpretation. The rule also tightened eligibility condition. If an organization has foreign national as key functionaries, except person of Indian origin, it will ordinarily not consider for FCRA registration or prior permission. Moreover, the definition of key functionaries has been expanded. It now includes directors, trustees, partners, office bearers, and even the Karta of a Hindu undivided family. Financial discipline has become much stricter because receiving another installment of foreign funding, an organization must utilize at least 75% of the previous fund. For renewal of registration, it must spend at least rupees 10 lakh on approved activities during the previous 2 years. The objective is to prevent accumulation of foreign funds. NGO must now disclose ultimate donors, official websites, social media accounts, publications, and other organizational detail. According to the government, this strengthens accountability and public confidence. Now comes the most debated part of the bill. The Hindu article argue that some provision may also have sledgehammer effect on civil society organization. Let's understand why. If an NGO's FCRA certificate is cancelled, it's not only lose the right to receive future foreign contribution, but even the assets created using those foreign contribution may vest in designated government authority. These assets may include office buildings, hospital, educational institution, vehicle equipments, and depending on the organization, even the place of worship. Initially, the vesting may be provisional. However, if the organization failed to obtain renewal or restoration within the prescribed time, the vesting may become permanent. The authority can later transfer these assets, auction them, sell them, or transfer the sale proceed to the Consolidated Fund of India. This is perhaps the biggest structural change proposed by the bill. Another unusual provision say that even if an organization voluntarily surrendered its FCRA registration because it no longer want foreign funding, the remaining foreign contribution and assets created from it may still vest in the designated authority. Critics question the rationale behind this provision. The bill also allows cancellation if the central government considers it necessary in the public interest. Here lies another concern. The term public interest has not been specifically defined. Supporters argue that flexibility is necessary for national security. Critics argue that such broad wording may lead to excessive discriminatory power. The bill also link cancellations with prosecution or conviction related to religious conversion through force or inducement and offense, including communal tension or disharmony. Supporters say that this protects social harmony. Critics caution that allegations alone should not become a basis for punitive actions and that safeguard against misuse are essential. So this is where the issue become important for UPSC mains. On one hand, Article 19(1)(c) guarantee citizen the right to form associations. On the other hand, Article 19(4) allow reasonable restrictions in the interest of sovereignty, integrity, and public order. In Ann Harper versus Union of India 2022, the Supreme Court upheld the constitutional validity of FCRA, recognizing it as a reasonable restriction. Similarly, in Indian Social Action Forum versus Union of India 2020, the court upheld the objective of protecting national interest, but clarified that only organizations involved in active or party politics should face restriction, not all voluntary organizations indiscriminately. The opinion article also raises question under Article 14, arguing that the exemptions clause allowing the government to exempt any organization in public interest could be challenged if applied arbitrarily. According to government, foreign funding must remain transparent, national security cannot be compromised, financial misuse should be prevented, NGOs should function with greater accountability, regulatory oversight protect Indian sovereignty. Whereas critics argue that excessive compliance burden many discourage genuine NGOs, broad cancellation power may create uncertainty, asset vesting provisions are too harsh, undefined terms like public interest could allow arbitrary actions, civil society organizations working in education, health, environment, and humanitarian sector must be adversely affected. As UPSC aspirant, we should avoid taking extreme positions. A balanced conclusion should be every sovereign country has the right to regulate foreign funding in order to protect national security and democratic institutions. At the same time, civil society organizations play an indispensable role in delivering education, healthcare, disaster relief, environmental protection, and social welfare. Therefore, the real challenge is not choosing between security and civil society. The challenge is designing a regulatory framework that ensures transparency, accountability, and national security, while other protecting legitimate humanitarian and developing work from unnecessary regulatory burden. That balance will determine the success of FCRA Amendment Bill 2026.